Hello, my name is Jason Vaughn, and I am the General Counsel for the Kentucky Realtors. And I'm here today to talk to you about a COVID-19 contract addendum that may help you if you are currently involved in a purchase situation between a buyer and a seller. I was asked to put this together by President Lester Sanders, and we have done it very quickly. As you can tell, I am working remotely from my home. And I am doing this in conjunction with some broker and agent input that we have received, as well as input from our AE members of our contract task force, as well as input from our staff at the Kentucky Realtors. So let me first start by saying this addendum is not perfect. It will not answer all of the questions that may be out there, but it is designed as a general addendum to be used with almost every contract in the state. It was not contract specific, meaning it could cross multiple contracts, whether they be from the Lexington office, the Board of Realtors in Louisville, the Board of Realtors in Henderson, or Bowling Green, or you name it. This addendum should be effective for your purposes. What is it designed to do? It's designed to help parties that want to still get to a resolution in a current contract, or potentially even one that was being negotiated at this time. But it's trying to get them toward a resolution that may have been interrupted by the COVID-19 situation. Now, this assumes that the parties are willing to be accommodating with each other, and it ultimately requires their agreement on whatever accommodations they're willing to do. It's also designed to escalate that level of accommodation through various options available within the addendum. So without any more ado, let's go ahead and look at the actual addendum. Now, as you can see, it has a initial part that you'll need to fill out, and you'll need to put the date of when you are putting this together. In addition, you'll need to make sure you list the buyers. And when I say buyers, it's plural. You need to make sure that you have all of the buyers listed there, as well as all of the sellers. And then you can put down the real property location, which is typically just the commonly known property address. Now, it then states that the reason that this is being created is because of the COVID-19 situation. And it has the buyers and sellers agree to the following. Now, there are 5 options. We're going to talk about all 5 options. 1 through 4 potentially work together or separately, except number 3 would have to be on work with number 2. And we'll talk about that. And then there's finally number 5 that we'll talk about as well. But let's start with number 1. If the parties check this box, then it states to extend all non-closing deadlines that have not already passed in the contract until blank date. Now, what does this mean? This means that except for essentially the closing date, any deadlines that are contained within the contract will be moved to this new date that the parties have agreed upon. So, for example, a survey inspection that was due in a week would now move to this new date. Or notifications with regard to some financing that were originally due on a week would then move to this new agreed upon date. But if the date has already passed, meaning there was a 10-day inspection period, let's say, and you're on day 20, that doesn't move. That's locked in. It's only on dates that haven't happened yet. And now what's the effect of this? The effect of this would be that the buyer, if that closing date came and they were unable to close, there would potentially leave the seller with a claim for breach of contract. Because even though the deadline has been extended, they're still potentially in breach if they don't purchase, meaning the buyer is still potentially in breach if they don't purchase. Arguably as well, the seller is potentially in breach if they don't move. Okay. Now, but the original contract date is still in place. Now, let's go to the second one. So let's say you've said, okay, our clients are willing to move the deadlines, but they're also willing to move the closing date. Then you would use number 2. And this states that if you check this box, to extend the closing date, the buyer's lender, you extend the closing date to the date the buyer's lender is prepared to close, or until blank date, whichever is sooner. Well, how does this work? Well, if you say that you put it out until April 30th, well, if on April 15th, the seller is notified by the buyer, my lender's ready to go, that's the new closing date, or shortly thereafter would be the new closing date because the buyer's lender is prepared to close. Now, if instead on April 30th or May 1st, the date was chosen, let's say May 1st was the last day to close, and the buyer comes to you and says, my lender's still not ready, then there's an argument the buyer's in breach because that is the final date. Okay? So the final date is the contract date. So if it happens and they can't close, arguably buyer or seller, whichever party is refusing to close, would still be in breach, but the closing date is extended. Now let's go to the next option. Now the next option, number 3, is what you would use in conjunction with number 2. And if you check this box, it states the following. If the closing date is extended pursuant to paragraph 2 of this addendum, and said date passes, either buyer or seller shall have the right to terminate the contract by written notice to the other party, and the earnest money deposit shall be returned to the buyer. So when do you use this? This is essentially you use if you say, look, we want this to work, but if it doesn't, when that closing date comes, whichever party cannot close or won't close, then we're just all going to walk away. The buyer can void it, or the seller can void it. Essentially, it's two-sided. Now, what's important to note about that is while it says that both parties are working toward it, both parties now can cancel the contract at the closing date. So, in the previous 2 examples, performance is still expected. In the third example, the third paragraph, performance may be waived by either of the parties. Now let's go to number 4. Now if they check this box, it's even more accommodating, arguably, to the buyer. It says, notwithstanding that buyer may have removed the financing contingency, buyer and seller agree that if the buyer's loss of income from COVID-19 related issues materially affects buyer's financing, then either party may terminate the contract by written notice to the other party up to the closing date, and the earnest money deposit shall be returned to the buyer. So essentially this means that if the buyer suffers an income-related loss that materially affects their financing, then buyer or potentially seller, if for some reason they were to know about all this, can get out of this contract even before the date of the closing. Okay, so even before the closing date, so even if you had checked 1, 2, and 3, even before that date, if the buyer has this loss of income, they could potentially get out of the contract. Now finally, if we've gone through all those efforts to be as accommodating as possible on this and it just doesn't work out, you go to number 5. And number 5, if checked, basically says buyer and seller agree to mutually cancel the contract and buyer's earnest money shall be returned to the buyer. So you're really only using number 5 if you have not already used 1, 2, 3, and 4. This is just essentially a mutual release. They're trying to get out of this contract. Now let's talk about the signature lines. And before then, let me also state that this also says that all other terms and conditions of the contract are ratified and affirmed and shall remain in full force of effect. So basically, things outside of the closing and what have you, they're all still in effect. This only adds to the contract. It doesn't replace it. Then we're going to talk about the signature lines. Again, make sure that you get the signatures of all the sellers and all the buyers. And some of you may ask, well, how come we don't have the broker signing this? Well, they could. We didn't include that because we wanted to leave it to the broker's discretion. If you don't sign it, there is an argument that your claims for a commission, should you want to try to enforce them at a later date, would potentially be preserved, or your claims would more likely that they would be preserved than as if you signed them, obviously, or signed them away. But if you do want to go ahead and do that and really just, tie a bow around this and end it, then you would want to have both brokers' signatures and agents' signatures on this as well. Now, hopefully we can get through this COVID-19 disruption as best as possible. Hopefully the COVID-19 addendum that we've put together will help. Also, during this time, if you haven't used it before, this is a perfect time to try and use the Kentucky Realtor Hotline, which is available on the KYR website. And again, this isn't perfect, but hopefully it can help you through this situation. Thank you.